Yama Warami Walimbimbi Warami Midiga Warami Daruga Nura Warami Walamata Warami Wanura Walamadikul. We welcome you on behalf of the ancestors, and we acknowledge all of the elders past and present. We acknowledge all Aboriginal nations of Australia. We walk together on this land, and we pay respects to the traditional owners and those who have walked before us. We acknowledge the land's history, yesterdays, todays and tomorrows. The land speaks of the Darug and their dreaming. We can still feel, hear and see the ancient songlines across this beautiful campus. This land has held many gatherings for centuries, since the Darug's first sunrise some 60,000 years ago. We belong to the land. We are many nations, many people, coming together, looking after this country and respecting each other. We stand here together at Macquarie on sacred ground. As the Wallamai navigate the mangroves and find their pathways, so shall you here at Macquarie. Warami, welcome to Walamata Duju Goyanu.
Welcome everyone to week 6 of the Go Program speaker series for legals and registration. So for those of you that may not have been to the Incubator before, the ladies' toilets are around to the left and the men's around to the right. We are filming this session, so if you wish to not be put on camera, just let us know and we'll make sure that you aren't. So I would now like to introduce you all to our 2 wonderful speakers tonight, Rachel Debeck and Judith Miller. So they'll be taking the session, and I think it's going to be pretty interactive, so get your questions ready. So over to you, ladies.
Thanks, Ali. Skipped already. Judith, do you want to introduce yourself?
I'd love to, Rachel. My name is Judith Miller. I've been a lawyer for 25 odd years, belied by my youthful looks, obviously, and I head up the national practice group at Wrays Lawyers. Rachel?
I've been practicing now for close to 20 years. You'll see there I've put reformed lawyer. I am still a practicing lawyer, but it's just not what I do with most of my time anymore. So until recently, I was part of BCG's Digital Ventures team, both helping to build that company and the various startups that they've been building. I left there very recently to join a healthcare tech firm to take on a people and operations role there. So I am excited to hear about what you've all been working on and some of the questions that you have. I'll let Judith just give you a quick overview of the firm that she works for.
10 seconds. We've been around a really long time, and we specialise in IP. So whatever questions you've got, I'm really hoping I'm able to answer. Otherwise, I'll be a complete embarrassment to the firm.
So what we wanted to cover tonight, so the topic was legal and registration. We do want to make it as interactive as possible, so interrupt any time whenever you have a question. I've been given this box to throw around. I'm not quite sure how successful I'll be in reaching my target, so come and grab it if it's too far away. But what we thought we'd focus on was just a few key areas to be thinking about, both for businesses that already are established, for those that have been that are in the early embryonic stages. So we thought we'd just touch on intellectual property, the importance of confidentiality and some of the legal risks to be thinking about there. Just a very brief overview of contracts, and then also just privacy, because it is such a topical topic at the moment, and some things to be thinking about from a new business point of view. Judith, do you want to give a really good legal disclaimer about the general advice that's going to be given tonight?
It's really general. But what you should be doing, and this is our goal today, is we don't expect you to walk out of here with a thorough understanding of everything that we're going to discuss. But what we hope you're going to be able to do is to recognise when an issue arises and that you need to go and seek specific and specialised advice, which is just for you.
Fantastic. Okay, so intellectual property. We're just going to touch on what it is, why it's important, and how to protect it. There's a few areas that we'll go a bit deeper on than others, but if you've got questions about particular categories of intellectual property, then please make yourself known. So why is it important, and why is it something that you should be thinking about? It is really important in terms of maintaining a competitive and market advantage to make sure that your key intellectual property is protected, and that you're avoiding some of the risks that can come with not doing so. It's, I'm not going to read out all these slides here, but there are obviously significant incentives to making sure that you protect the creative ideas and products that you develop. And should you reach a point where you are selling or seeking investors into a business, intellectual property becomes really important from a business valuation point of view as well. So some common attributes of IP rights, territorial in nature, and we'll touch on that in a bit more detail for some of the categories that we'll go through. Generally finite terms, except for trademarks and confidential information, and the scope of the monopoly is determined by reference to prior art. So just jumping in now into the types of IP rights, and I'm sure you're familiar with all these various categories, but it's some of the details in each of these that you might want to be thinking about when you're thinking around business ideas or what's within your current businesses. So patents really covers how something works, devices, methods, processes. Trademarks, if you think about that, is how something's known. It can be a word, a phrase, logo, sounds, sense. Typically you'll find it's a word, phrase, or some form of logo. Design protects really how something looks, pattern, user interfaces, etc. And copyright protects how something's expressed. And you typically hear about copyright from, in terms of books, movies, songs, but also thinking about that from the perspective of, particularly for digital businesses, things like the software code that's being written that underlines software that's being built. And then some of the less common ones, circuit layout rights, plant breeders' rights, and confidential information or trade secrets, which is really anything that's kept a secret, and that can be client lists, formulas, recipes, depending on the business that you have. So I might hand over to Judith to give a quick run through on trademarks.
Thanks, Rach. So it's basically a sign or an insignia saying to people, this is the origin of goods. Everybody's probably seen trademarks. It can be a letter, it can be a device, it can be anything at all. It can also cover our scents or, the colour purple. Cadbury tried for it years ago and had a big fight with Darryl Lee, you may recall. So is everyone fairly familiar with what a trademark is? Now, there's a big difference between a trademark which is registered and a trademark which is unregistered, which is sometimes called a common law mark. Okay? So what we're really looking at today, I hope, is to impart to you the importance of actually getting a registered trademark as opposed to just having a common law trademark.
Has anyone here registered a trademark before, in the process of registering a trademark?
Okay. So you'll know that there's actually a registration procedure. You actually need to apply to IP Australia. Sorry, Rachel, I think we just might be onto the next one there. That's working well.
There we go.
So what it does do, it provides you with protection. So what you are able to say to somebody once you've registered a trademark, I have a monopoly over this trademark. So if you choose to use this trademark, I am able to sue you and obtain damages and an injunction to prevent you using the mark. Okay? And this is the benefit of actually having a registered trademark. If you're not registered, then what you've got to do is rely on other rights. And those other rights are basically passing off and suing under what is called the Australian Consumer Law for misleading or deceptive conduct. So it's much better for you to have a registered mark. Now, the benefit of a registered mark also is that it serves as a record of what you've owned, of what you own. And so if somebody's searching the register, they'll know that there is a risk that if they use a mark which is similar or identical to that mark, that there's a risk that you're going to be suing them. So it kind of wards them off doing that. Now, to be registerable, there's a couple of things. It's got to be capable of distinguishing the goods from your competitors, and it can't be similar. Now, one of the points about being capable of distinguishing is it can't be descriptive. So, Rachel, I think if we go to the next slide, and this is a really great example of a trademark which is capable of distinguishing and one which is just purely descriptive. So, Abacus Computer Superstore. Abacus could mean anything. Apple, the same thing. It means nothing in relation to computer programs, so it's capable of distinguishing. But look at the next one, outdoor furniture specialists. What do? They do outdoor furniture. Completely descriptive, completely incapable of distinguishing their goods. So, actually, I think we've gone a bit too fast. So a couple of other things I should say is, sorry, I've raced through this, but there are a number of classes, and they cover both goods and services. So the idea is to work out what you want to register in relation to, and then you get your description, and that's what you register. You register in a class, and you register in relation to the specific goods or services which you offer, and it's really important to get this right up front. So what sometimes happens is, one, somebody goes and registers a trademark in one class, and they only register in relation to it, but they register in relation to the whole class. Somebody comes along and they start using that same trademark in relation to another class that is completely unconnected. You won't be able to do anything in relation to that. Secondly, you may only be using your trademark in respect of some of those goods in that class. Your mark then becomes vulnerable to removal for non-use if you haven't used it in relation to all the goods or all the services for which you've registered. Now again, I'm not expecting you to remember all of this, but I am hoping that you're going to take away that there is some complexity to getting the application right in the first place. So 3 things. 1, you should always do a search to make sure that the trademark is available for you to use. 2, you should register, and you should register early because you never want to be in a position whereby somebody jumps in over you. 3, it's, as Rachel described before, it's all territorial. So just because you've registered in Australia doesn't mean that you've got protection around the world. So, but you can actually, there's this thing called the Madrid Protocol, which actually allows you to kind of jump on board and get it in a whole range of countries if you apply after applying in Australia within 12 months. But it's an expensive process, but it does give you protection, and you can keep on renewing your trademarks every 10 years or every 15 years. So you can, depending on where you've registered. So it's really important that you do that. And sorry, Rachel.
Can you pass me?
Oh, there's a question.
Okay, we might just go through a few of the misconceptions.
Yeah, because I think these are important.
And part of the topic that you've been looking at is legal and registration. And we're not getting into the registration side so much tonight, but there are a few misconceptions around trademark that are worth thinking about. So business names and company names. So there's a misconception that ASIC gave me a name, therefore I own it. They're quite separate things.
Oh, and that I'm able to use it.
That's right. So there's no interaction at the moment between the ASIC name register, for example, and the trademark register. So it's just worth remembering that those two things are quite separate. Business name system, again, is purely administrative. Who's trading behind that name? So the important thing to remember, and this is a misconception that comes up quite often, particularly when people are challenged or opposed for using particular names. They said, well, but I own the business name or the company name. It's not intellectual property, and it doesn't give you any exclusivity in relation to the name. So just be thinking about those sorts of things, both in relation to the businesses that already exist and any ideas that you've got going forward. Another one to cover, which Judith's really touched on with the Madrid Protocol, is just around international trademarks. which is around a belief that if you've got something registered in Australia, then I can enforce that registration globally. As Judith touched on, you really need to file and register a trademark in each country that you want to seek protection in. And you need to use it in those countries.
Absolutely, because if you don't use a trademark, it's vulnerable to removal. You don't use it for 3 years, and use doesn't have to be all that much. So this gentleman over here mentioned, up on a website, that's use, that's sufficient use. But sorry, one of the other things, and I should very quickly point out, sometimes if you've got a group of companies and you don't have the licenses in place, if there's one holding company, and this is often a very frequent structure, you'll have a company which holds all the IP, and they're the ones that license it out for the group members to use. If that license is not in writing, and there's no control by the holding company, even though the other subsidiaries have been using that trademark, they haven't been using it in the trademark sense, and it becomes vulnerable to removal for non-use. So that's, again, just general, something to have in the back of your mind.
So make sure when you're applying for the trademark that the right entity is the
absolutely.
owner of the trademark. A Madrid system we've touched on. Domain names. Who's got a domain name or applied for a domain name? Yeah. So pretty straightforward process to applying for a domain name. Again, similar to the business names, company names, there's no ownership around from a trademark perspective because you happen to own a domain name. Nor does it indicate that you wouldn't be infringing someone else's trademark by if the domain that you wanted was available. And you can infringe a trademark by registering a similar sounding domain name. So it doesn't have to always be identical.
Yep.
It can be similar sounding, and you might find yourself on the end of a trademark infringement proceeding. Copyright.
Yeah.
Very quick overview.
Yeah.
Copyright protects expressions of ideas, and then those expressions are limited to those that are defined within the Copyright Act. Includes things like text, music, drama, sound recordings, video recordings, etc.
And sorry, just on that text, remember that includes code, software code.
Very important for digital businesses. And copyright, do you want to run through this?
So it's a bundle of exclusive rights. So effectively, you can prevent somebody from, if you've written a book, for instance, you can prevent somebody from copying that book, from distributing that book, from communicating to the public, to performing it in public, or making an adaptation of it. These are what are called the exclusive rights of the copyright owner. So the owner themselves can do it, and if you do it without the permission of the owner, then it's copyright infringement. Oh, sorry, I should. The other thing is, you've actually, where you've got a right, like a trademark or a patent, as we're going to go through them, that's what we call a monopolistic right. So it doesn't matter if you haven't searched the patent register. If there's a registered patent there, you just can't do anything in relation to that patent. Copyright is different. Copyright is actually the reproduction of that particular work. So, for instance, the Bee Gees wrote Staying Alive. If I independently, without ever having heard Staying Alive, come up with exactly the same song, that is not copyright infringement. That's a terrible example, but I think you know where I'm going with it. Copyright is actually, it's not a monopolistic right, it's a right to prevent somebody from exercising your exclusive rights. And so, and you don't have to, and we'll go through the misconceptions, but also, what copyright doesn't protect is an idea. It protects the expression of the idea. So the actual words, they have to be original. So, you can't, obviously, it's got to be your own, what you've come up with yourself. It's got to be original, but it doesn't protect your idea. It protects the expression of an idea. So if you just say something out loud, it's not protected. It's got to be reduced to a material form. That's the other thing that's important. So again, as opposed to the rights that you've got to register, patents, trademarks, designs, copyright protection is automatic. The expression which you may or may not have heard in relation to a creative work is protection is created the moment the pen springs from the page. So the moment that you reduce it to a material form is the moment that you have protection. There's no registration required in Australia. In the US, it's slightly different. If you want to sue in the US, you've got to have registered first. Since 2005, in relation to original artistic, musical, literary works, author's life plus 70 years. So a whole lot of movies, for instance, will be coming out of copyright, and there's what you will have heard, you know, songs which are called PD, public domain. Anybody can perform those songs because the composer has been dead for 70 years. That's it. And they've got to be original, and I mentioned that before.
Okay. Do you want to touch on maybe the important exception?
Yeah.
Which, if you're thinking or you've already got employees, thinking about copyright from an employer point of view is actually really important.
Absolutely. So the general rule is the owner of the copyright is whoever creates it. An important exception to that is employees. So if an employee creates something during the course of their employment, then it is owned by their employer. Okay? And there's a whole lot of cases on this, and particularly in relation to university researchers and lecturers and people like that. When was it created? How was it created? It's got to be. So if my job is to code software, but I also happen to have created a song, that won't be in the course of my employment because it's something completely separate. A huge misconception is in relation to contractors. Just because you pay for something doesn't mean that you own it. So if you've engaged a contractor to create something for you, the contractor will own the copyright unless there is an assignment in writing signed by that contractor in your favour. And this is a real problem with startups. They get people in, they get friends to help, they get contractors in because they don't have any employees, they don't have any paperwork, and at the end of the day, they want to exercise their rights in relation to that particular piece of copyright. They want to sell their company and they don't have the records and they don't have the rights.
The good news is though, it's an easy fix if you're thinking about it.
Yep.
So if you're getting someone to do any freelancing, contractor, anyone who doesn't have an employment relationship with you, making sure that you've got documentation in place where that person assigns the copyright to you or the entity that you're running means that you avoid the pain that can come with finding out that the freelancer or contractor that you've used has retained intellectual property which you've paid for.
I can just give a very brief example. When I was a junior lawyer, I was asked to go do due diligence on a huge acquisition of a crane company, global crane company. They had a whole range of, they had a big room with all their records in Sydney, and I was to go and do it. I spent the day in there. They could not prove that this is a $1 billion company. They could not prove that they owned any of the drawings because they hadn't kept the records. The deal never went through, and that's just an example because the important thing that is that I hope that you take away is get things right from the beginning.
Okay, we might whiz through.
Yeah.
Moral rights. We won't get into moral rights.
The misconceptions are quite important, though.
Very quickly on some of the misconceptions. Downloading and sharing pictures or files from the internet is okay if it's for personal use or research.
That's a misconception.
Not okay. It's an infringement. Taking 10% of anything is okay. Who's heard that sort of stat before? You can take a bit.
It was okay, but let's not use that for the moment because that does become confusing.
And so what we're really talking about here is from a commercial perspective, and there are all sorts of
exceptions and fair educational use. Yeah, absolutely. Yeah.
I made a copy, but I gave the author credit. I'm not using it to generate revenue, so it should be okay. We paid for it, therefore we can reuse it. it's just not that straightforward. As we talked about, there are various different exceptions, but it's really important to focus on what the copyright protection gives you and what infringement is, rather than thinking that these things will get you around an infringement of copyright.
Yeah.
There's some key takeaways here. Seek permission or advice before using someone else's copyright. Use a copyright notice, and that's the C in a circle, and attribute it. And obtain licenses to background copyright that you need to use the copyright of your own. And costs of permission and advice are relatively inexpensive compared to what it might cost you if there's an infringement. It's the same as what applies with the trademark. The cost of actually applying for the trademark and making sure you've got those registrable rights are actually relatively inexpensive compared to what comes if you infringe someone else's rights.
And I think there's a next one, what to do. Yeah, keep records. I mean, that's the most important thing, is to keep records. That will save you a whole lot of heartache later on. Check your employment agreements, check what your other contracts say about ownership. Have I included copyright notices where relevant? Do I need to consider registration in the US or somewhere like that, where there's a jurisdiction which requires you to register before you can seek to enforce your rights?
Okay, we're going to go very quickly through patents. Patents are it's quite a technical area, so definitely one to seek expert advice on from a patent attorney.
As opposed to a trademark, you can never register a patent by yourself. There's just absolutely no way.
But a patent will give you the exclusive right to exploit the invention and to authorise other people to exploit it, and that includes hiring, selling, using or importing. Standard patent gives long-term protection for up to 20 years. An innovation patent, which is a relatively fast and can be inexpensive, it just depends, protection option, that lasts for a maximum of 8 years. There's a registration system for patents, which I won't get into too much detail on.
But you have to register in, just because you've got a patent in Australia gives you no protection anywhere else around the world. You've got to have a registered patent in that particular jurisdiction for you to get protection there.
And in thinking about do I have a patentable invention, these are some of the questions that you might be asking yourself. Have I developed a new product? Have I found a new solution? Have I identified an unknown or unexpected property of a known product? Or have I improved an existing product? I think we might... one of the important things to remember about patents is that it must be novel.
Yeah, and as I said before, freedom to operate searches are incredibly important. So if you think you've got something that is in a field of endeavour that may very well be covered by a patent, you absolutely must go get a freedom to operate search, which is effectively somebody looking at what is there out there to make sure that you do not infringe. So there's two things which are really important here. One is, if you've actually got something that should be registered, you should go seek to see if you can get it registered. But the other thing is, don't do something that you think might be infringing, because people apply for patents and they sue all the time on patents, and it can be extremely expensive.
So patents must be inventive and innovative, and there can't be any secret use of the invention prior to the priority date. And that's
so
a
important.
really important
So
point
important.
to remember.
And just one thing, social media, and you see it quite often, you know, people are very excited about what they're doing, and they say, oh look, I've done this fantastic research, blah, blah, blah. You've lost your rights. People publishing papers, researchers love to do it, and they lose their rights. Universities are, God bless them, great places for knowledge, sometimes not so fantastic when it comes to protecting IP rights.
So you'll see that I've just skipped through design, so
Yeah.
if anyone wants to know anything about design, ask us about it after. One really quick question.
Do you have to register your patents simultaneously all over the world? Or can you start in one country and your product sells, you start patenting it?
Well, it'll depend. No, well, it'll depend, because there's a window of opportunity. So you really have got to do it pretty quickly, with, 12 months, really.
Okay, so just very quickly, a few other things to be thinking about as you create and build businesses. Confidentiality came up earlier in the discussion around NDAs and intellectual property assignment. Information must have the necessary quality of confidence about it, and an obligation arises when information is given in which the circumstances indicate that the other party should have known or should reasonably have known that the information was confidential. So a breach of confidentiality occurs when there's unauthorised use to the detriment of the party disclosing the information. So just some tips for maintaining confidentiality. There's not a strict need for a written agreement such as an NDA, which we talked about earlier, but it's best to have one because it means that there's far less, I should say, ambiguity around what was disclosed or what the intention was of the parties in discussing or disclosing that information. Keep records of who the information is disclosed to. Clearly mark anything that's confidential information or that's really important confidential information for your business. Mark it confidential. Restrict access, shred confidential documents, and train your employees. Continuously have discussions around the importance of confidential information so there's not inadvertent disclosure.
Yeah, I mean, the classic example is always two employees talking in a public space, and that really, you'll lose your confidentiality there.
Okay, now contract masterclass in 30 seconds.
Yeah.
Are you ready? Offer and acceptance. These are some of the things that some terms that you might want to become familiar with in terms of understanding whether or not there's a contractual situation. Offer and acceptance, consideration, capacity, intention, certainty, written versus oral.
So effectively, Rachel, will you mow my lawn for $60?
Yes, I will.
Thank you. Offer, acceptance, consideration, certainty. Just one thing about certainty. Oftentimes I hear so many clients say, oh yeah, we agreed that we would agree a price later. You've got to have certainty as to all your essential terms. That's what's called an agreement to agree. So any time that an essential term is not agreed at the outset, you will not have certainty and you will not have an agreement. And one of the things that Rachel's going to do on the next slide, which is so important, agreements don't need to be in writing to be binding. The only agreement that actually needs to be in writing to be binding is a contract for the sale of land. So you can still be bound by certain things, even if it's an oral agreement.
I think we're not advocating that you shouldn't have them in writing.
You absolutely should have everything in writing.
But a contract exists despite it not being in written form, except for the exception that Judith has talked about.
So just going back to, I mean, look, contracts are so important. You see so many businesses at the beginning just sign anything. They will have unlimited liability oftentimes because they're using somebody else's paper. And I'll tell you what, if you sign a contract with unlimited liability, you are really risking the entire business. Really, I mean, that's all there is to it. You've got to be really careful about what you sign. And I know at the beginning people are desperate to do business, but do not sell away your future to get a deal done. 2, always make sure you've got insurance. Always make sure you've got insurance for whatever risk you're doing. The flip side of that, who are you dealing with? What liability? What happens if someone's providing me goods or services? What happens if this all goes wrong? How quickly can I get out of this agreement? Do they have insurance? Who am I dealing with? Are they reputable? I will give you this example. I used to do a number of agreements, very large players, and a Chinese company came in, I'm not going to say the name, as a competitor to my client. They were offering unlimited liability. If I'm a customer, I'm actually really worried about a provider to me offering unlimited liability because they're offering it to everybody. And if they get sued by another client, they're out of business. Just a few things for you to think about. Contracting is a whole, we could spend, and you do. It's a university course that goes for a year. Anyway, these are just a few things to think about. And the point is, get legal advice on your contracts, really.
Privacy will be our final section here. There's been a lot in the press over the last few years, and particularly recently with some changes to mandatory data breach reporting around privacy. Key piece of legislation is the Privacy Act. The Act is administered by the Office of the Australian Information Commissioner. Commonwealth government agencies have to apply, others need to apply. The one that you might want to just think about from your business perspective is businesses and not-for-profits with an annual turnover of $3 million or more need to comply. That doesn't mean, though, that you shouldn't be thinking about privacy before you reach $3 million turnover. I'm sure you're all going to build businesses that will exceed that threshold. But there are a number of...
but also a couple of things. One, it's good practice for yourself to do that. But also, if I'm an individual and you don't have a privacy policy up there, I'm thinking, why am I going to provide my personal information to you? What are you going to be doing with my personal information? Secondly, if you're doing with business with anybody who knows what they're doing, they will not be wanting to do business with you.
And this is where there's the overlap as well with the contract topic that we were just talking about. Even if you're not at a threshold level of having to comply with the Privacy Act at the $3 million threshold, often suppliers, other organisations that you're dealing with will require in their contracts with you that you comply with the Privacy Act. And you'll need to meet that bar anyway. The other part to think about from a privacy perspective is reputational damage. Even if you weren't strictly required to comply with the Privacy Act, the reputational damage, and we could have too many slides here around all the companies that have been in the press globally in the last 12 months.
The CBA.
Yeah, that's right.
Just this week.
And so there's increased expectations from individuals and of which all of you are, I'm sure, part of that, around what companies will do with personal information, how they'll protect it, and the sort of regimes they'll have around that. So it's something that, even if it's a very small business to begin with, it's something I would really recommend that you start thinking about from the earliest stages, what you're storing the information, how you're storing the information, what you're using it for, and making sure that you've got a framework in place that enables you to comply with the Privacy Act.
Yep.
We've just gone over time.
Yeah,